Welcome to the Hong Kong office of Jindu. At Jindu, we take the wearing of masks very seriously because masks can help to contain the virus. But masks also have a very beneficial business effect. For example, in the case of business cards. And in extreme situations, we have this type of mask when we visit our clients. It's a great honour to be asked by CIETAC Hong Kong to speak on this topic, how to draft a DR clause in light of COVID-19. And let's have a look at the new reality, which is really happening now in international and domestic arbitration. There are so many obstacles: restricted international and national travel, working from home without usual levels of administrative and technical support, illness at all levels of an organisation, social distancing, bans on gatherings of X or more people, curfews. And the question is, should we adapt the DR clause? Do we need to adapt the rules? Shall we rely on the discretion of the tribunal? Is none of this needed? And when you're looking at the CIETAC rules, certainly there is some foundation for some flexibility there. You can see there, for example, that the tribunal can examine the case in any way it deems appropriate. It shall hold oral hearings or can examine on the basis of documents only. It can hold deliberations, I think that means among itself, at any place or in any manner. And the chairman, the presiding arbitrator, can decide on the procedural arrangements. So there's flexibility there, but when you look at the actual model clause itself for arbitration that you could insert into a contract, it is in reality beautiful in its simplicity. And while every arbitration clause will rest on its particular wording, and looking at this clause and the rules as a reference point, there are still several reasons parties may want to seek to agree some straightforward DR clause changes before a dispute arises, rather than relying upon the tribunal's general discretion. While arbitral tribunals are familiar with the concept of remote hearings, many rules start from the presumption that hearings will be oral and conducted in person. And without amendment, applications and clarifications will be needed. Applications take up time and increase costs. There's reduced scope for delaying tactics if, in the DR clause, the parties have agreed that documents can be served electronically and hearings can proceed remotely. And amendment is relatively easy. Now, when we are talking about amending a DR clause, it should not and does not just contain the arbitration agreement. Very often, there is a chain of pre-steps that the parties have to undertake before they go to arbitration. Sometimes meetings of the parties' chairmen, chairpersons, sometimes mediation. There's often a series of steps. And I think that there is some scope for the DR clause to be improved in light of COVID-19. So where, for example, there is to be a meeting of employees, what about saying that meetings between the parties may take place remotely via a mutually convenient video conferencing platform or telephone? And where there's talking about mediation, what about the parties agree that mediation can be conducted remotely and that they will work together and with the appointed mediator or organisation to arrange a remote mediation? What about no party can commence arbitration proceedings until X days after? What about to say the commencement of mediation shall not prevent the parties commencing or continuing arbitration proceedings in relation to dispute under the arbitration clause? Whatever you decide with a dispute resolution clause, setting out the steps pre-arbitration, the case law is very clear. There needs to be clarity. I had a whole arbitration in London where the pre-arbitration steps were not clear, and the parties spent many months and a lot of money arguing whether the pre-arbitration steps had been fulfilled. So let's turn to the arbitration part of the clause itself then, and think about remote hearings first of all. Can interim applications, or applications that don't require witness evidence, proceed on a documents-only basis? Now, the CIETAC rules currently assume that hearings will be oral unless the parties or tribunal agree that a hearing can be document-based. Now, the presumption in the DR clause could now be reversed, and there's a very good precedent for that in the CIETAC online rules. They say that unless the parties agree to hold oral hearings, or the arbitral tribunal decides it's necessary to do so, The arbitration tribunal shall hear the case on a documents-only basis, in accordance with the written materials and evidence submitted by the parties. So that's just a guide as to what might go into a COVID anticipatory dispute resolution clause. Then, perhaps, you might want to include express provision for remote hearings. For example, the parties agree that oral hearings may be conducted remotely via an appropriate video conferencing platform. Now, the question for us today is, how much detail should we put in to this DR clause? Should we remain procedurally flexible and let the rules and the arbitration tribunal itself decide how to implement what we just already discussed? Or should we impose a little bit more detail into the dispute resolution clause? Parties who wish to add more detail could, for example, agree that a video conferencing platform will be chosen which allows for screen sharing. It is available in all regions where parties and witnesses are based, and allows the tribunal to control access to the platform and monitor who is on the virtual platform to ensure that confidentiality is maintained. Now, parties who do wish to draft this more detailed protocol may want to consider the following additional questions. When, if at all, and probably only on agreement of all the parties, the tribunal can hold a video conference with only one or some of the parties. And something which I've personally experienced very successfully, whether the presiding arbitrator can him or herself conduct procedural hearings on their own. And this happened very successfully on a very large arbitration that I was able to conduct as counsel, where the chairman, as he was called in that particular tribunal, did a very good job at chairing procedural conferences with the other two arbitrators situated elsewhere in the world, and he then informing the other two arbitrators after the procedural conference, and they then issuing a procedural order. So that's something very well worth thinking about. Now I'd like to turn to the DR clause and witness evidence. Now, there are concerns about witness evidence being given remotely. Obviously, confidentiality, but what about security of information, witness coaching, and the effectiveness of cross-examination if the advocate and tribunal don't have the witness in front of them, and if the distance of a video link removes some of the pressure of the witness box? And what about the admissibility of the witness evidence per se? Well, the parties could address these concerns by initiating in their DR clause that where possible, the tribunal will arrange an independent party to sit with the witness when they give their evidence. Such a person could administer the oath, check that the witness knows how to work the technology and access electronic documents, and provide a safeguard against witness coaching. Additionally, the parties might express that the fact a witness has given evidence via video link will not of itself affect the admissibility and relevance of weight of their evidence. So let me recap some of the COVID-related issues you may want to put into a DR clause. The service and filing of documents and inter-party and tribunal communications electronically. The approval of the use of e-signatures and electronic seals. A signature, seal, or other authorization of a document shall include an electronic signature or seal. Again, the definition section in Article 20 of the online rules are very good starting points. Will they work in lockdowns? Are they clear, or should we in fact amend the DR clause itself? An agreement that hearings may proceed remotely. Consideration of how to manage remote witness evidence. Acknowledge that extensions or stays may be inevitable if parties cannot participate remotely. Now, I started by saying that one had this dichotomy of deciding whether one should amend the rules, whether one should actually amend the DR clause. And I've only just started this slide, and it's not part of my remit today to go through the CIETAC rules and suggest amendments, but certainly in the future, it may be that arbitration institution rules can be tightened up to cover for COVID-related situations. But until they are so tightened up, it may be very wise to think carefully about the dispute resolution clause, both in terms of that layering of pre-arbitration steps that I mentioned earlier, and in terms of the arbitration clause itself. Thank you very much.